First question for the vote is: do I look better in real life or on the photo? Um, so we are talking about limitation. Better remind myself. And let me just introduce this talk. Building Safety Act, Section 135, introduced a new limitation period for claims under the Defective Premises Act. Going forward, so from June 22 onwards, there's now a limitation period for claims under the DPA of 15 years rather than the 6-year period that used to be in play. More interestingly, some might say, going backwards, so for claims in respect of developments that were completed before June 2022, there's now a retrospective limitation period of 30 years. And 30 years is the magic number you might have heard already in the context of remediation contribution orders, because those too can be made in respect of buildings that were, or developments that were completed within that historic 30-year period. And it's a retrospective limitation period. It applies to historic claims, even though it was only brought into effect in June 2022. So you would think, crikey, that's bad. What's the exception to that? There isn't much. The exception that you get is in subsection 5, where a claim that is made in reliance on 30-year limitation period must be dismissed if that claim would give rise to the defendant's breach of the defendant's human rights. Now, everyone in this room may all blanch, because if you're like me, you won't have done anything about human rights law, perhaps since you left university. I can even tell you when my first day of pupillage was the day when the Human Rights Act came into force. So let's just say I am not an expert in human rights. So human rights is an exception. The only other exception is where the claim has already been settled by way of compromise, or it's already been determined in court or arbitration. So what you're going to hear next is Paul Berry, who's one of our resident geniuses, who appeared in one of the main building safety cases called LDC and George Downing. He was my junior, but he's so good I let him do the hearing by himself. He's going to tell us about the recent Supreme Court decision in URS and BDW and how that applies in the context of limitation. And then we're going to work through some examples led by Connie. So, and just say Connie is one of our new tenants, but she's brilliant too, because I judged her in an advocacy exercise with our other junior tenant, and they were both genuinely fantastic. So I know it's going to the graveyard slot, but it's going to be worth it.
Thank you, Jonathan. And before I start on URS and BDW, I have to say that although I've been in some of the cases relating to the Building Safety Act and its issues, I wasn't in URS and BDW, and the credit for some of these slides has to go to those who were, which is Simon Hargreaves and David Sheard, neither of whom were able to be here today, unfortunately, to give this talk. So I hope I will do justice to their slides and to some of their thinking. The URS and BDW case will probably be familiar to almost everyone in this room, and it is, for the purposes of this talk, happily, the only occasion in which Section 135 has been considered by the courts to date. The background to the case started actually as a cladding case where investigations were carried out of the Cityscape block in Camden, which was developed by BDW in the late 2000s. URS were appointed by BDW as structural engineers, and in the course of investigating cladding issues, serious structural concerns were raised over the stability of the block, such that the block was actually evacuated, bought by Barratt to purchase back all of the flats, and demolished. The claim that Barratt issued against BDW was commenced in March 2020, so before the Building Safety Act, and therefore in tort only. But once the Building Safety Act came into force, BDW amended to add new claims under the Defective Premises Act and the Contribution Act. And it's that amendment application that essentially formed the meat of the appeals that went all the way up to the Supreme Court that we're concerned with today. You might ask why this point was important. The BDW had claims, as I said, in negligence, and they also wanted to bring a contribution. And the amendment was potentially important to the negligence claim because the existence or not of an in-time liability, or following the Building Safety Act amendments, what would be deemed to have been an in-time liability, the works were carried out, was potentially relevant to the classification by URS of BDW's actions in buying back and remedying the blocks as voluntary. It's also important to the contribution claim, and as usual with the contribution, the 1978 Act, it's a bit complicated as to why it is, but because section 1.2 of the Contribution Act, outside of section 1.4 claims under the Contribution Act, where a claim's being settled, contribution the liability under the Contribution Act towards a payment made in satisfaction of a liability would only be available where the claimant was liable, including any claim not having been time barred, immediately before the payment was made for which the contribution was being claimed. If the claim was time barred, then BDW would have faced probably insurmountable issues progressing its Contribution Act claim against URS. Now, these issues are quite specific and may well become of historic interest concerning parties who carried out remedial works pre-Building Safety Act coming into force and then sought to claim back the costs. But of broader significance, obviously, in the Supreme Court's judgment is the reasoning and their elucidation of the purpose behind the Building Safety Act and the provisions relating to the Defective Premises Act. So the two parties' cases, URS's case, can be summarised as set out on the slide. Firstly, section 135 had retrospective effect for direct claims brought under the Defective Premises Act, but was not retrospective for all purposes, i.e. claims in tort and under the Contribution Act simply didn't have retrospective effect in the way that BDW alleged. Secondly, where the question of limitation arose in a collateral way, i.e. in negligence or under the Contribution Act, section 135 should not be treated as having changed the law retrospectively, and in support of that proposition, they relied on a general presumption against the retrospective application of any statute. And thirdly, they said this was consistent with the wording of section 1355, which says that where an action is brought that but for subsection 3 would have been barred by the Limitation Act 1980, a court hearing an action must dismiss it in relation to any defendant if satisfied that it's necessary to do so to avoid a breach of that defendant's convention rights. And it was said that this safety valve on its face only applies to an action that would be barred, and barred is synonymous with time barred, and that is only relevant to a direct action under the DPA. BDW's case, in brief summary, was that the wording of section 1353 was clear and unqualified and was not limited in its application to claims brought under the DPA. And they relied on the wording, the amendment made by subsection 1 in relation to an action by virtue of section 1 of the DPA, i.e. it didn't say in relation to a claim under section 1 of the DPA. And then secondly, the clear purpose of the statute was to ensure that claims could be passed down to those who were ultimately responsible for defects. That's consistent with claimants who had carried out remedial works in circumstances in which others were primarily responsible, to be able to pass that liability down the line to those other parties. As we know, the Supreme Court decision was in favour of BDW. Section 1353 was not limited in its application to direct claims under the DPA. And there are two main judgments. There's Lord Hamblin and Lord Burroughs, who co-wrote a judgment, and Lord Leggett, who wrote a judgment that, broadly speaking, concurs. And Lord Hamblin and Lord Burrows said, although the most obvious circumstances in which the 30-year limitation period will apply will be under the DPA, this is not specified or stated because it simply refers to the action, and Section 153 does not refer to an action under Section 1 of the DPA, but uses the broader expression an action by virtue of Section 1, and therefore it can apply to negligence and contribution. Lords Hamblin and Burrows went on to say that Section 1355, which remember was the safety valve under the convention, the Human Rights Convention, was also to be read widely and would apply whether the question of limitation was under the DPA arose for the collateral purposes of negligence or the Contribution Act. And they dismissed the argument that the wording barred in some way limited Section 1355 to the DPA. The words barred were sufficiently wide to cover the collateral purposes, including negligence and the Contribution Act. They also emphasized the policy rationale. A more restrictive interpretation would result in incoherence and be inconsistent with the purpose of the Building Safety Act. So therefore, accepting what was submissions by Barrett, but also submissions made on behalf of the government in the Supreme Court. So ensuring that those directly responsible for building safety defects are held to account was central to the BSA and various of its provisions, including specifically Section 135. This purpose would be seriously undermined if that was not done. One of the interesting stings or slight potential twists in the Supreme Court's reasoning is when that retrospective application would be relevant in considering the legal test of liability and causation and mitigation. Because whilst Section 135 tells us that the retrospective effect of the Defective Premises Act is to be treated as if it was always in place, it doesn't necessarily follow that the fact that the Act has been given retrospective effect is irrelevant when considering the reasonableness of Barrett's actions in the context of causation and mitigation. And Lords Hamblin and Burrows said this, paragraphs 120 to 121. The availability of a limitation defence means that the liability was legally unenforceable. Section 135 has changed the legal position by removing that limitation defence. It does not, however, purport to change any historical fact, nor does it seek to alter a person's subjective state of mind. Issues which depend on matters such as what was or should reasonably have been known, understood or contemplated or believed at this historical point in time are unaffected by Section 135. This case provides an example of how Section 135 would not alter facts. If there's an issue at trial as to the reasonableness of BDW's action in carrying out the remedial works as a matter of legal causation or mitigation, then that would fall to be determined by relevance to the facts at the time of those actions. And there's a similar statement in the judgment of Lord Leggett at paragraph 299 of the report. It's difficult to see how, in practice, this distinction is going to play out, since obviously the facts are not in a vacuum. Knowledge of the law and the limitation period is a fact which may well, and is quite likely to in most of the cases that we're concerned with, impact on a person's subjective state of mind in deciding what to do in relation to a breach. But does that mean that it becomes unreasonable to carry out remedial works where there is no claim in time against a party, no claim against a party in time at the time the decision to carry out those remedial works was actually taken? There's some indication in the reasoning in the Supreme Court that that might not be the case. Elsewhere, the Supreme Court had relied on the existence of a potential DPA claim at the time of the works, despite it being out of time, as a factor in Barrett not acting voluntarily. They noted that limitation bars the remedy but does not extinguish the right, and the fact that the remedy existed was a relevant factor in determining that Barrett may not have acted voluntarily. Alternatively, if a relevant fact is that the Defective Premises Act remedy was barred, given there's a causation mitigation point, there may be little application of this distinction in practice. There are very likely to be other factual reasons why a claimant would act reasonably in remedying a defective building and then seeking to pass that claim on. In other words, if the only reason a claimant can proffer to the court as to why it remedied the building is the retrospective impact of the Defective Premises Act, then the claim is likely to be quite a difficult one to run anyway. But it does give rise to some room for debate, and it may be something that we come on to discuss further in the examples. And with that, I think I'm handing over to Jonathan to explain some of my examples.
So what we're going to do, I'm going to read out the example, and I'll ask the question. Connie's going to answer it expertly. If I or Paul have anything they want to chip in, we will. But then equally, if anyone in the audience would like to chip in, you're more than welcome to also. If only just to prove that you've been listening, or if you need to do it for your own CPD purposes, that's fine too. So the first question, the first factual scenario is this: 1998. So before I even started pupillage, Mini Barway, a small family development business, develops a new property. Today, Greyshade, the owner of the property, seeks to bring a claim against Mini Barway under Section 1 of the DPA for fire-related safety defects. Mini Barway kept all the documents relating to the build on paper, as we did back then, and disposed of them after 6 years in 2004. The extent of the potential claim brought by Greyshade would force Mini Barway into insolvency were Greyshade to succeed. Connie, can Mini Barway escape liability using Section 1355?
Okay, so a reminder that Section 1355 provides that an action will be dismissed if the court is satisfied that it is necessary to do so because of a breach of the defendant's convention rights. Don't worry if your human rights law knowledge is not totally up to scratch. The most important one is the right to a fair trial, which fortunately is probably the one that we will know. So the courts are yet to consider this threshold, and so we don't know exactly how high a bar it is. We can, however, be fairly confident that the mere passage of time is unlikely to suffice. Otherwise, Section 1355 would undermine the very purpose of Section 1351. So we're looking for a special factor. Now, in this hypothetical, our special factor is that the documents were on paper and have consequently been disposed of. So is that enough? Well, in my view, that probably isn't enough, and I say that for two reasons. Firstly, the claimant will have disclosure obligations and of course bears the burden of proof. And so the defendant is likely to be afforded some documentary access. Secondly, we're not told in this hypothetical that there's any reason why the defendant can't give witness evidence. And so I think that the court is most likely to take a pragmatic solution, which will probably involve giving that witness evidence more weight than might usually be afforded if documents were available. And I would imagine the court's more likely to take that approach than to allow liability to be totally escaped by reason of Section 1355. The position might be different if the witnesses were unavailable.
I think the other point to bear in mind is that with DPA claims, lots of people who might bring the claim may never have documents. If you think about it, people who subsequently purchased flats in a building, or in this case, the freehold. And typically what drives the DPA claim is the presence of defects. And that's generally established by expert investigations and the like. So my instinct is that human rights challenges on the basis of absence of documents aren't going to get very far unless someone in the position of the defendant can say that those documents would make a material outcome to the case. For example, if it was believed that there were subsequent amendments or modifications to the building that have somehow, and it said that they have given rise to defects rather than any work that the original developer carried out, for example. So that's what I would say. But have we got any human rights experts in the audience? Or anyone?
I am now. One other example potentially of the type of situation you just mentioned might be as regards the scope of takes on work, where you haven't got the contract, you haven't got specification, it's not clear, therefore whether it's you or so responsible for that sort of work.
Yes, and certainly I think it will be a more fruitful line of argument for those people who've had only a narrow role in relation to the development, rather than say the design and build contractor or the developer who's essentially going to be responsible for everything. So yeah, we'll have to watch the space. Anyone else got any thoughts on human rights? Okay, well, in respect of your human right to stay awake, let's move to the next one. Barway is the developer of a block of flats built by a contractor, Multi-Bridge, in 2000. Soon after, Barway sold the properties. In 2018, Barway was alerted by the new owner of the block, Grayshade, to potential defects in the development. Barway understood that any claim against them would be out of time because of the original 6-year limitation period. Consequently, Barway did not investigate the defects any further. Now, Grayshade brings a DPA claim against Barway, who pays £4 million to remediate the works. Barway seeks to recover against Multi-Breach. The cost of remediating in 2018 would have been half as much as the cost today. Connie, has there been a failure to mitigate?
Okay, so the starting point with this one is section 1353, which provides that the amendment made by subsection 1 in relation to section 1 DPA actions is to be treated as always having been in force. Now, Paul has told us that in accordance with the decision in URS and BDW, what that means is that the legal position is retrospectively changed, but the factual position is not. Now, that gets somewhat difficult when we're thinking about reasonable mitigation, which is both a factual and an objective inquiry. And it's somewhat difficult to ascertain the objective facts without thinking about the real or artificial retrospective legal context. I think probably what URS and BDW are telling us to do is to acknowledge the factual truth that in 2018, it would have been reasonable to understand that there was no legal claim or legal liability in respect of the defects, and to consider the action in light of that factual truth. However, even acknowledging that factual truth, personally, I am not satisfied that Barway's actions amount to reasonable mitigation. Firstly, in failing to remediate the defects any earlier, Barway acted contrary to the spirit of the Building Safety Act. And we might say that this is one of the exact types of mischief that the Building Safety Act was introduced to prevent, namely developers and owners irresponsibly refusing to remediate defects in buildings. Secondly, technically, the reason that Barway did not remediate the defects in 2018 was not because they understood there to be no legal liability or legal claim. Rather, they thought that any liability or claim would be successfully met by a limitation defence. Now, traditional mitigation principles tell us that the duty to mitigate will arise when the claimant knows that the defendant is in breach. Here, even sticking to the actual reality rather than the retrospective change in reality, that position is 2018. If Barway wanted to take the risk of not mitigating their losses because they thought that any legal claim would be met by a limitation defence, then they should properly bear the cost of that risk in the event that the legal landscape changes and it subsequently becomes advantageous for them to bring their claim. So I think on this one, they can expect their damages to be reduced.
Judge Connie has spoken.
I mean, yeah,
I think if you were in Barway's position, you might find that to be a harsh result. And what you would want to do if you were advising Barway, I think, is try and investigate what you can as to the facts leading up to their decisions, not to investigate the defects further. Because, I mean, it might be that Barway didn't know that multi-breach were in breach in 2018. And that is a relevant factor in terms of their mitigation. Might also be that multi-breach itself, conversely, were aware that there were issues with the building in 2018, and their inaction may also be relevant to the question of whether, of who essentially takes the risk of this change in process between 2018, when there's no liability, and whatever we are in 2025 now. So it may be that if you were in Barway's position, you'd want to dig a bit further into the facts of this case and see if there was some way to spread that risk around.
Anyone got any observations on this? No.
I'm trying to scratch now back the judgment, possibly not involved in the case where emphasis happens. But putting that point to one side, my recollection is there was quite a lot said about the approach of Matthew's to both document attention and also that attitude to have engaged with me, which would influence the decision. I think on this point, and also the previous case, the previous example we gave. So I was just interested in views on that. So my recollection is a little bit scanty because it's why it's given.
Yeah, I mean, my recollection is that they raised that as a natural justice argument in the adjudication and then on enforcement. And I mean, this was an adjudication enforcement attempt to resist enforcement. Raising natural justice arguments in such contexts is always a bit of an uphill struggle. And I think the court in that case undertook a fairly detailed investigation of all the steps in a long history of communications of the claim backwards and forwards between the two parties, and suggested that more could have been done by Ardmore. I think it was to investigate. They could have at an earlier point in time investigated the claim. All of it shows, and that perhaps is unsurprising in the adjudication enforcement context, but it also does chime with what we're talking about here, which is the court doesn't seem to be massively sympathetic with defendants who run arguments that they were not able to properly investigate claims at earlier points in time post 2017. And you can see the reasons for that as well, I think.
Yeah, and you see in a similar context in Martlet, I'll try and say this nicely because Simon's here, but in Martlet, a similar issue arose about alternative remedial schemes, and we see that a lot when a defendant comes up and goes, oh yeah, you can just fix it using this magic spray or whatever. Of course, when the claimant was doing the work and deciding what work to do, this alternate solution was never proposed. So when you come along later and say, oh, we could have just done this, it never goes down so well if you've not really engaged. So I think that's all I would add on that. We'll do one more, which is this one. Might say the obverse of what we've just been looking at. Greyshade is the owner of a block of flats built by a developer, Barway, in 2000. In 2018, after investigating the safety of the flats, Greyshade finds defects. Greyshade believes that Barway is to blame for the defect, but thinks that any claim will be time-barred. Nevertheless, Greyshade decides that remediating the defect will be great for the image of the company and therefore pays to remediate the block. In 25, having remediated the block, Greyshade decides to pursue a claim against Barway under the DPA for the cost of the remediation works, having learned about the extended limitation period provided for by Section 135. So, Connie, is it a defence for Barway to say that Greyshade's motivations for remediating the defects were the real cause of Greyshade's loss?
Okay, so short answer, no. Starting with Borealis and Geogas Trading, it would be difficult to conceive that anything less than unreasonable conduct could break the chain of causation. So is this conduct unreasonable? Well, presumably not. So the very purpose of the Act is to encourage responsible remediation of buildings. It would therefore be very surprising if the court took the principles of causation to prevent recovery where somebody had remediated the building in advance of being told that they had to do so. Also, because in accordance with Rendlesham Estates, the loss caused by the breach was, in that case, the lack of and need for a sound roof. The compensation is ordinarily a sum which represents the cost of repairs, but that's irrelevant to the loss, which is the defective state of the building. So here, it's clear that the breach has caused loss, namely that the building was in a defective state. Gratia's motivation and decision to remediate that defective state should be irrelevant. The compensation for the loss is the cost of the remedial works, irrespective of whether, when, and why those works have in fact been carried out or not.
And just, I mean, also in this context, there's, although the Supreme Court in BDW and URS didn't determine any of the factual issues because they were just considering the amendment application and some other preliminary issues. If you read it's particularly the judgments of Hamblin, they get very close when they consider the voluntariness principle to picking out particular factors, which mean that BDW was not to be considered to be acting voluntarily when it carried out those the remedial works. And that's at paragraph 60, I think it's 62 to 65 of the judgment. So in this sort of context, the Supreme Court's given a pretty clear steer on what it thinks of parties that carried out remedial works pre implementation of the Building Safety Act, and then try to recover those from other defendants, i.e. it's pretty sympathetic to them.
I think I would just add, remember in BDW had no proprietary interest in the building at the time it decided to remediate. This is a different factual scenario. This is an owner actually remediating their own building. So I think that the scope to argue, well, you only did it for your own commercial reputation, it is not going to be a particularly strong argument. Now we have a choice, and we'll do a straw poll. We've got one more factual scenario to go. It's 3:30, so coffee break, but I can offer you this deal. If we do the final factual scenario, I promise to go shorter when I tell you about the Building Safety Working Group. So we do a quick straw poll. Who would like to hear more of me, Connie, and Paul now? Who would like to hear less of me afterward? Right, next one. So Greyshade, the owner of the ground floor of a block of flats, is considering a claim against Barway in respect of defects in the external walls, which have given rise to damp and mould throughout the building. Barway completed the flats in 2019. Greyshade realises that the limitation period for claims under its contract with Barway is about to expire, but is still in the process of investigating, formulating and understanding its claim. Should Greyshade issue the claim form to protect the contractual limitation period, or should they just forget about their contract claim and just simply rely on their DPA claim?
Okay, so probably fairly obviously, the sensible course of action would be to issue the claim, protect the contractual cause of action, and then feed both the contractual and DPA causes of action. This is because there are certain limitations on the DPA claim. Those include the unfitness for habitation test. In accordance with Bowl and Huntsfield, this isn't a particularly high test, but it will exclude minor defects. Perhaps more interestingly, it is important that the particular dwelling is rendered unfit for habitation. So here we're told that they are the owner of the ground floor flats, and the defects are in the walls. So we're probably safe, but had the defects been, say, in the roof, as in Rendlesham Estates, then the position might have been different and the DPA claim could have been more difficult. The usual benefit of the DPA claim is, of course, the purpose of the talk, which is the extension of the limitation period. Now, that doesn't apply here, but that doesn't mean that the DPA claim is of no benefit. There would still be reason to plead the DPA claim in the alternative to the contractual cause of action if, for example, the contractual cause of action contained a limitation on damages. That limitation would apply to the contractual claim, but would not apply to the DPA claim. So there are benefits in retaining both causes of action, and the important thing to do would be to issue and then pursue both.
Yeah, I mean, I agree with that. This seems to come up all the time at the moment. And although the DPA is an excellent remedy for many claimants, it doesn't have all the advantages of a contractual claim. And therefore, if you find that you have a contractual claim that is potentially still in time, then the prudent course of action is to do everything you can to try and retain that claim, not least because in our world where many of the contracts have, in addition to the reasonable skill and care obligations, strict liability obligations in relation to building regulation compliance. And that is potentially a major benefit for claimants in trying to get these claims over the line. The test under the Defective Premises Act, Section 1, is that I think the best that can be said for it is that it's more complicated. And the courts have still to really tease out all of the issues that the wording in Section 1 gives rise to in any particularly clear way.
Yeah, I would just add that the contract claim might give you better and stronger arguments in relation to breach as well. So if you think about Defective Premises Act claims, typically your reference point is the building regulations, approved document B, if we're talking about fire safety, and maybe some other British standards. But if you just take, for example, the chestnut of combustible insulation, there's always arguments depending on which version of ADB you're applying about whether or not combustible insulation fell foul of the building regulations. Whereas if you've got a contract standard or a contractual specification that, for example, expressly prohibited the use of combustible materials, it's a much easier case. So I think we're all in agreement for lots of reasons, and it's now coffee time.